Oversight of the U.S. Copyright Office. I'll introduce her in a moment, but I want to thank Registrar Perlmutter for joining us today, and I look forward to your testimony. I'd also like to thank Ranking Member Tillis and his staff for working together again on a consensus basis. Senator, you and your folks continue to be great partners in the conduct of hearings and the work of this subcommittee. Copyrights are an important topic, and I'm glad we've gotten to hearing about them today. We express our ideas and our spirit and our emotions through stories and through art, which are captured in television shows, novels, paintings, songs, and movies that help bring our imagination to life. They help create our culture. They help connect people across space and time. And our founding fathers recognized the critical importance of the expressive arts and enshrined in the Constitution the power of Congress to create a national copyright system to help artists and authors and musicians protect their work. Congress passed the very first federal copyright law in 1790 and established the Copyright Office a century later. But the environment facing the Copyright Office then, or even in 2022, when Registrar Perlmutter last appeared before the subcommittee, is very different than the one we confront today. Copyright owners are looking for quick and convenient ways to register and protect their artistic creations. Online streaming of music and video is now ubiquitous and easily pirated by those looking to steal content. And most critically, the rise of generative AI asks us to consider what artistic creation means in the first place. It's against that backdrop that Registrar Perlmutter and the 450 public servants at the Copyright Office do their work. You have an annual budget of $100 million. You registered 450,000 copyrights last year, but there's one copyright that Registrar Perlmutter and your team didn't register, a copyright for a work created by generative AI. Registrar, your office has played a leading role in studying the intersection of AI and copyright law, embarking on an ambitious effort to publish a multi-part report on the implications of this new technology for creators, legislators, and courts. The office has issued the first part of its report, addressing the rise of AI-generated, highly realistic digital replicas, concluding that the time has come to adopt a federal law regulating digital replicas at the federal level. Along with my colleagues, Senators Blackburn and Klobuchar and Tillis, we have introduced a bill called the No Fakes Act that does just that. Our bill provides everyone, not just celebrities or the famous or those who make world-leading films or songs, everybody, with the right to control their digital replicas. It sets the rules of the road for licensing or transferring those rights and creates a system to encourage online platforms to swiftly remove unauthorized digital replicas without chilling vital First Amendment protections. Digital replicas are just one issue that AI presents to us. I welcome your testimony on other issues at the intersection of AI and copyright law. I'd like to hear from you today, in particular about digital piracy, which costs our economy at least $30 billion a year and puts hundreds of thousands of American jobs in the entertainment industry on the chopping block. One way to combat digital piracy is no-fault injunctions, which block access to foreign websites that provide unauthorized access to copyrighted materials. I suspect many of us in this room remember the SOPA and PIPA fights of 2012, but much has changed in the intervening decade. Dozens of countries, including the United Kingdom, South Korea, Israel, the EU, many EU member states, have implemented no-fault injunction systems that have proved effective, and they've done so without chilling protected speech. Registrar, I know your office has been studying this issue, and I look forward to hearing from your findings. But finally, I want to discuss some of the work your office is doing to make the copyright system more accessible. You're updating your IT systems to make registration easier. You've launched the Copyright Claims Board, or CCB, outlined in the CASE Act that Senator Tillis and I co-sponsored. We've designated that, or designed that, to be a streamlined and less expensive and voluntary alternative to federal court. It's accepted over 1,000 claims, but has decided just 24. I want to dig into that a little bit. And then last, you have a lot on your plate at the Copyright Office. I'm excited for your thoughts on these issues and to discuss the work we're doing in Congress to ensure protection for copyrighted materials. Before I proceed with your introduction, I'd like to turn to my ranking member, Senator Tillis, for any remarks you'd like to make.
Thank you, Mr. Chairman, and thank you, Register, and for everyone for being here today. I appreciate you holding the hearing in this oversight for the U.S. Copyright Office. Last week, Senator Coons and I texted each other after the election results, and I responded to him saying, one thing that's great about our relationship is about the only thing that will change in this subcommittee is who holds the gavel. It's been great working with you. It's been great work over the last Congress, and I look forward to another very productive subcommittee going into the next Congress. And really also hats off to your staff. I know our staff and your staff have good working relationships. But now we're here talking about the intellectual property system, especially when it comes to original works of authorship, including literary, dramatic, musical, and artistic works such as poetry, novels, movies, songs, computer software, and architecture. The copyright system and the IP rights in general are paramount to our domestic innovation and the success of our economy. Today, we look at the important work of the U.S. Copyright Office. They've just completed the triennial review of Section 1201, I should say, rulemaking, and are undertaking many other important initiatives. They're continuing their first periodic review of Mechanical Licensing Collective created by the Landmark Music Modernization Act. Over the summer, the USCO issued an important new rule on group registration of news websites. But there are still big outstanding questions. The rise of generative AI will raise numerous questions related to copyrights, both in terms of ingestion and outputs, and we will hear today about the steps taken by the office to prepare for the upcoming challenges. And I don't know if any of you paid much attention to the election, but there was you could already see the threat. You can see the threat just based on content that's already out there. It's only going to become more challenging, and we've got to get our hands around it. I know that you've released Register, I believe, the first in a series of reports about AI, and I'm interested in hearing more about that. And the function you see these reports serving has been instructive to rulemaking or either policy recommendations to this body. Online commercial piracy remains a problem that must be addressed in the copyright space. There are a number of proposals in that space that Congress will look at in the near future, and we've got a lot of work to do. Also, before we get started with the oversight hearing, I want to thank Senator Blackburn for being here. Senator Blackburn, I think, probably gets one of the gold stars for attendance in these subcommittee hearings. And it's why I always offer that she go before me when she shows up at these hearings, because I appreciate her investment of time, and I also look forward to working with my colleagues on the other side of the aisle as we make more progress in the remainder of this Congress and in the Congress to come. Thank you, Mr. Chairman.
Thank you, Senator Tillis. And I, too, look forward to hopefully one more hearing before the end of this Congress, and then hopefully a similarly productive, engaged, and active subcommittee in the next Congress. I believe we've had more hearings than any other subcommittee of the full committee.
Yeah, I think the staff would agree with that, right?
And we certainly have legislative product that we're going to keep trying to move forward. Let me now turn to our witness. Today we welcome the Honorable Sheriff Perlmutter, Register of Copyrights and Director of the U.S. Copyright Office. Register Perlmutter was appointed in October 2020 and leads a workforce of 500 and a budget of about $100 million. Prior to assuming your current role, you served as Chief Policy Officer and Director of International Affairs at the PTO and spent time in the private sector as Associate General Counsel at Time Warner for IP. You hold an undergraduate degree from Harvard and a law degree from the University of Pennsylvania. I'm very grateful to have you here before us. After I swear you in, you'll have roughly 5 minutes to make an opening statement, and then we'll proceed to questioning. Depending on attendance, we will likely do several rounds, although we will be interrupted by a vote at some point. Register Perlmutter, could you please stand to be sworn in? Please raise your right hand. Repeat after me. Do you swear that the testimony you're about to give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Register Perlmutter, you may proceed with your opening statement.
Update you on the recent accomplishments and current initiatives of the Copyright Office. The office has achieved a lot since I last appeared before you, and I will describe the highlights. These include our ongoing study on the copyright implications of generative AI, completion of the second year of operations of the Copyright Claims Board, publication of the 9th Section 1201 rulemaking, progress in IT modernization, and expansion of our outreach and economic research. The recent developments, the recent advancements in generative AI technology and its uptake by the public have placed AI at the top of our policy agenda. Last year, we launched a major AI initiative, beginning by issuing guidance on how to register works incorporating AI-generated content. We followed with a notice of inquiry seeking public comment on a full range of copyright-related issues. We received and have reviewed very carefully more than 10,000 comments. We are now producing a report analyzing the issues and making recommendations. At the end of July, we issued the first part addressing the topic of digital replicas or deep fakes. Given current gaps in state and federal law, we concluded that it's urgent to establish a federal right that protects all individuals from the knowing distribution of their unauthorized digital replicas. We also made recommendations as to the contours of such a right, including First Amendment accommodations and limitations on transferability. In the coming months, we plan to issue the rest of the report, covering the copyrightability of materials created using generative AI and the legal implications of training on copyrighted works. We hope it will be useful to Congress, as well as to the courts and other agencies in considering these important issues. And in 2025, we plan to update our registration guidance and make relevant revisions to the Compendium of Copyright Office Practices. The Copyright Claims Board, or CCB, has been fulfilling Congress's goal of providing access to copyright justice to those who cannot afford to litigate in federal court. The CCB is running smoothly, with just over 1,000 claims filed to date coming from all over the country. The parties range from individuals and small businesses to Fortune 500 companies, and the majority are self-represented. The CCB's decisions so far have been hailed as fair and reasonable, and we will shortly launch a review of its operations as required by the statute. Last month, we concluded the triennial rulemaking under Section 1201 of the DMCA to adopt temporary exemptions to the prohibition on circumventing access controls. I recommended to the Librarian of Congress that she renew or grant over 24 exemptions, and she adopted my recommendations in full. The office also continues to support amending the statute to add more permanent exemptions. IT modernization remains a top priority for the office. We are building the Enterprise Copyright System, or ECS, a seamless, user-friendly system that will connect all of our services. We've made significant progress, while at the same time bringing processing times for both registration and recordation down to historic lows. Two of the major components of ECS, recordation and public records, are now available to the public and are garnering very positive feedback. Today, nearly 90% of all recordations are made online, and processing times have been reduced from months to weeks. The Copyright Public Records System is being readied to become the authoritative source for registration and recordation data in 2025. Our current priority is accelerating the pace of development of the ECS registration component, which is the most complex and widely used of our services. We are planning to initiate a limited pilot on critical functionalities by the end of the year. We've briefed the Copyright Public Modernization Committee on all of this and consulted with them on participation in the limited pilot. In order to achieve this planned acceleration and meet growing user demands, we will be requesting additional support through appropriated funds for FY26. To further our strategic goal of copyright for all, the office has been increasing our outreach activities to reach new audiences and also to raise awareness of new resources such as the CCB. The last time I reported to the subcommittee, the office had just hired its first chief economist, and his team has now developed an ambitious research agenda. They've issued several reports to help identify underserved communities. They've built a hub for public access to bulk copyright data for research, and they've prepared analyses of costs and demands for our services to support our next fee study. So let me close by thanking the subcommittee for its continued support for the Copyright Office, and I would be pleased to answer any questions.
Thank you very much, Registrar, both for your testimony and for your hard work leading the Copyright Office. As you referenced in your testimony in March last year, your office kicked off an ambitious effort to study three of the biggest questions at the intersection of artificial intelligence and copyright law, how to regulate AI-generated digital replicas, whether that output should be copyright eligible, and how to think about the use of copyrighted materials to generate AI training sets. That's not yet complete, but you did issue the report on actually calling for federal legislation, as you just referenced. As we move our bill, the No Fakes Act, forward, could you discuss what you think we should keep in mind about that bill and what should be changed or included about the No Fakes Act?
Well, we were very pleased to see the bill being introduced. I believe it was the same day that a report came out, so It was a red letter day for this area of the law. And in a way, the most important thing is to take appropriate action swiftly, because the harms from these unauthorized replicas are multiplying every day. In terms of the content of the legislation, I think there are many areas of commonality between our recommendations and what is in the bill. In particular, those parts of our recommendations that we felt were especially important, such as covering all individuals against uses that might not be commercial in nature, were taken up in the bill. It also contains limitations on free transferability to protect individuals against being taken advantage of, making sure that licenses are appropriate. And it contains a safe harbor to incentivize the swift removal of unauthorized replicas from the internet. So the elements that we saw as critically important are contained in the bill. In the areas where there is some divergence between our recommendation and the language in the bill, these were areas where we carefully analyzed the pros and cons and thought that there were arguments on both sides. So we are more than happy to continue to offer technical advice as the bill moves forward, which I hope it will very soon.
Thank you. So do I, and we look forward to that ongoing technical advice. One of the areas you're next looking at is whether training an AI model on copyrighted works constitutes fair use. Is there anything you're comfortable sharing with us about that at this point, and is there a role for Congress in addressing that issue?
This is, I would say, the most controversial of all the areas that we're addressing in the report, and the one that the majority of the comments did address. It is, of course, also the area where there are now, I believe, about 36 court cases pending, several of them class actions brought by copyright owners from various different sectors. There are not yet any decisions addressing the critical fair use issue, but I'm sure they will start to come in the next year or so. What I will say is that of the comments that we received that did address the issue, by far the majority of them expressed the opinion that the existing law in the United States was adequate to deal with this issue, and that was primarily the fair use doctrine. Of course, views diverged strongly on whether what type of use of copyrighted works in the development of AI systems and tools constitute fair use, and what types of uses do not qualify as fair use. We will be exploring that thoroughly in our report, but it is interesting that at present, again, the vast majority of comments said there was not a need to change the law. It was a question of how the law should be applied. I imagine, however, that once court decisions start being issued, we may start to see parties come to Congress asking for some change.
Well, in the event that happens, which I would expect, we will look for your input, the very talented folks on your staff. In the next round, I want to get to the question about piracy and injunctive relief. But let me just close by asking you what keeps you up at night about artificial intelligence and its impact in particular on copyrighted materials.
I think the thing that keeps me up the most is the speed at which all of this is developing. Yeah. Because obviously Congress wants to, and the Copyright Office wants to act with due diligence, as well as promptly enough to make a difference and to be ahead of the curve as needed. And that's difficult to do when almost every week there's some new development being reported in the paper. But to me, I think what is critical to all of us is, on the one hand, to make sure that we don't impede the development of this exciting technology, but that we figure out how to do that in a way that ensures that what is special about human creativity can continue to thrive. And finding that balance is a challenge, and we will be trying to address that in the report.
Thank you. That is an important balance to strike. Now let me turn to my colleague who, if there's anyone in the Senate who is familiar with all the latest developments in AI, having tried them out recently, my colleague.
This morning,
Tom
actually.
Taylor.
Thank you, Mr. Chairman. You were talking about the comments. I was going to ask you about the theme. You said about 10,000 comments have come in. And you're saying there's we don't need anything. We don't need anything new. We just need the fairness doctrine to be applied. Do you have some sense of where they're coming from? I mean, I'm on banking committee. We're talking about crypto. When we get messages back on nothing to see here, it tends to be from people that are heavily invested in crypto. I mean, do we know much about the comments to know if this is a kind of defensive mechanism up against people that are, betting future business plans on it? It's a broad swath. How would you characterize the feedback now and the nothing to see here, just let the courts take care of the application?
Yeah, it's interesting because the view that fair use is the appropriate doctrine to handle this is being expressed by what you might say both sides, or maybe all sides.
Okay.
On the one hand, I would say the technology companies and some consumer groups and public interest groups are saying this should be fair use. If it were to be held not to be fair use, it would not be possible to develop this technology given the volume and variety of copyrighted works that are used in training. They are pointing to a line of cases that looks at the use of copyrighted works internally for purposes of analysis and comparing the training of AI models to those cases. On the other hand, the copyright owners are saying it cannot be fair use to take everything that we've produced through a lifetime of training and inspiration and to use it as raw material to create content that will compete with us in the marketplace. And so both of them are relying on fair use, but they are reaching opposite conclusions. So that's what we will be. Our goal in the report, I would say, is to provide a framework for analysis to explain how the fair use doctrine and the various factors the courts must consider should be approached in the context of different fact patterns.
That was going to be my follow-up. What precise role? What are you going to put out there to give reference material to good decisions that are going to go through the court? Minimally, what kind of instruction? What kind of role can you play on an immediate basis?
Well, I think that's the role we're looking at. It's very difficult to say that an entire category of activity is fair use or isn't, because it is a completely fact-specific
I think a part of the reason why you may have a broad spectrum saying, let's see what the courts are doing, is because they're afraid of what Congress may do. And so a part of what we have to do is be very educated. We have to have a light-handed approach. I believe that AI is going to unleash an opportunity for innovation this country has never seen and really even set us apart, make us more of a leader than we already are globally. We don't want to have a chilling effect on it. I did have a couple of other questions. Number one, you were talking about the ECS, and I think you said that you've gone from recordation from months to weeks. Is that 36 months to 36 weeks, or is it like a couple of months to a couple of weeks? Give me an idea what that metric really means.
For entirely paper-based recordations, we are talking multiple months, sometimes more than a year. For completely online, if there's no correspondence needed, which is the vast majority of the online recordations, we're talking about less than a week.
Great. Well, that's great news. In September, several House Judiciary members wrote you regarding concerns with what they described as the proliferation of performance rights organizations. What's your response?
I understand the issue. Performance rights organizations play a very valuable role in helping to make licensing easier for everyone. But where there is a proliferation, and there are more and more, it's critically important for users to know what repertoire is represented by whom, so they can make their decisions.
Yeah, it seems like some of the more well-established ones I'm not concerned with, but there's a multiplication here that's concerning me, and be interested in maybe getting a report back from you all on the current state of play.
We are planning to follow up by issuing a notice of inquiry and looking into what the experience has been.
Last one, and then you're currently in the midst of a 5-year review of the Mechanical Licensing Collective, MLC, created by the Music Modernization Act. What insight can you give us into this process?
We are currently reviewing the input that we've received. We have asked for both public input and also for the existing entities to give us a report on how they're doing and what they've been doing.
Can you comment on any concerns about transparency at the MLC?
No, we are listening to input about what all of the concerns are and taking it seriously.
Thank you, Mr. Chair.
Thank you, Senator Tillis. Senator Hirono is going to defer to Senator Welch. Senator Welch.
Thank you very much. Thank you, Chairman and Ranking Member. I want to follow up a bit on the questions that the Chairman was asking about creative material. It's really tough for many artists, and if their material is used to train AI, my view is that they should be notified of that. My view is that they should be compensated for that. But there's no way in which they can actually get the information. And I'm considering legislation that would make it more possible for them to do that. But first of all, in terms of your experience and your position, are you getting expressions of concern from the creative community about the use of their work to train AI and their inability to have any way of determining whether, in fact, that's the case?
Yes, absolutely. I mean, certainly concerns about the use of their work to train AI, and that's where we will be talking about the fair use analysis in our upcoming report, but also the transparency issue, because the copyright community the copyright owners are expressing concern that unless they know if their work was used to train, they can't do anything about it, whether it's to license or to bring a lawsuit.
And that's true.
That's true. So, and this is an area, of course, that touches other interests besides copyright as well. There's a lot of reasons why transparency is important in AI training.
And what's the pushback on that?
My understanding of the pushback is that it's really more about what kind of transparency, how much, and to what degree of detail, and how would it be provided. And I know that discussion has been going on now for some time in the EU as well.
This is pretty simple. Your work, your creative work, it's used in training or it's not, right? So how much more transparency do you need than the company training its AI model to ask them the question, did you use my song?
Yeah, my understanding is that one of the issues is the extent to which it's possible to reproduce, to identify exactly which works were used in which training model.
So, there's something really wonderful about this. AI, knows everything, right? Except that which the artist needs to know to determine whether their work has been used to benefit AI. So can we take seriously this assertion by the AI folks that know everything, that they don't know what work they've used in order to train their wonderful AI model?
Well, I do think it's important to have that level of transparency to allow copyright owners to make decisions about what they want to do.
But we're in a new world here in a sense, because it was never contemplated with the fair use doctrine that there was such a thing as AI that would utilize and vacuum up not only information but creative content from artists who are always getting squeezed with the use of their model. So it sounds like we do need some explicit protection for artists if their work is used to train AI models.
Well, I would differentiate between the use of the works in the training and transparency about what works are used. So I think the fair use doctrine is flexible enough to deal with the training, but transparency is an additional issue.
In order to have the fair use doctrine interpreted and applied to a concrete situation, then there has to be transparency so that the court or the decision maker knows the initial question, this creative content has been utilized for the benefit of the AI algorithm.
Yeah, I mean, not just the fair use doctrine, but the entire infringement analysis could only take place if you know what works are used.
All right. Thank you very much. I yield back. Thank you, Mr. Chairman.
Thank you, Senator. Senator Blackburn.
Thank you, Mr. Chairman. And Ms. Perlmutter, I enjoyed our conversation yesterday, and thank you for taking the time to come by. And as my colleagues have said, the work you do is important to my fellow Tennesseans that are songwriters and artists and authors and musicians. Your office is vitally important. I will say also to a lot of our healthcare innovators that have patents, it is vitally important, and it's why we are seeking to work on this issue and protect the constitutional right that our innovators have to benefit from their creations. I remind them all the time, Article 1, Section 8, Clause 8 is about them, and we should be protecting that. I want to stay with the fair use question for just a minute, and I appreciated your report. We touched on this yesterday, and I appreciated the opportunity to submit my comments on the topic during your notice of inquiry last year. And I've said before, and this is something we say a good bit in Nashville, fair use is a fairly useful way to steal my creation. And we've seen this happen a lot in the music industry first and subsequently into others. And I addressed and argued for a narrowed application of that standard in the Warhol versus Goldsmith case, which, as you know, sided with the original photographer in that case. And I think that having that clear understanding is vital. So coming a different way from my colleague's question, when we talk about this, and you talk about this unlicensed AI ingestion of copyrighted works, then should that or should that not be considered under a fair use doctrine?
Well, the fair use doctrine applies as long as you have an initial act of reproduction. And one of the beauties of the fair use doctrine is, even though, of course, it was developed at a time before the existence of AI, or certainly generative AI, it is flexible enough to apply to new technologies. So the doctrine applies. How you apply it, though, is a different question.
So then you would apply it in that, and I think that's an important distinction.
Yes.
That yes, indeed, it does apply because of that flexibility. And therefore, that gives standing to these original creators to go after bad actors. And of course, with the No Fakes Act that Senator Coons and Senator Tillis and Senator Klobuchar and I have, this is something that would provide that extra protection for these creators. So whether it's copying their voice or copying their works, they have a legal standing and a right to defend themselves in their creation.
Yeah, which is important because copyright law doesn't extend to protecting images and voices in themselves. So I agree that's important. And also, just to clarify, when I say fair use applies, I mean the doctrine is available to analyze that situation, not that we've concluded that any particular conduct is fair use.
As you said, it has flexibility.
Yes.
Okay, I want to ask you about something else that has come up recently with some of our artists, and this is Spotify's bundling system. And as you can imagine, we've got a lot of people whose music is on Spotify, and they're not really happy with this. And they feel like what Spotify did with offering audiobooks. And then, you know, they're doing this, these standalone subscriptions, and then they reclassify 50 million users. And in the end, the creator gets less money. So I'd like to have you comment on what protections are there, because every time somebody does this, every time Spotify does this, when you look at them coming up with these bundle plans and offering the audiobooks as a free service, if you've got the monthly music subscription, and then turning around and doing a book subscription standalone a little bit later, and then reclassifying their 50 million users, it is Spotify that's making the money, and it is the creator that gets fewer pennies.
We're certainly aware of the
Okay.
issue and of the litigation. I can't comment on the merits of the pending litigation, but we are following it. It is the issue of how you calculate the royalties for bundles is not something that the Copyright Office is directly involved in. It really is a question of the regulations of the Copyright Royalty Board. But we are certainly following what's
watching.
happening in the
I
litigation.
appreciate that. Thank you, Mr. Chairman.
Thank you, Senator Blackburn. Senator Hirono.
Thank you, Mr. Chairman. It's very clear that when we deal with AI and the impact that it has on just about everything in every sphere, it's really difficult to figure out what kind of regulations there should be. But it does occur to me that there are other countries that are having the same issues. And one of the questions I'd like to ask you after I make some initial comments is, how are these other countries dealing with this issue? But thank you for joining us. I know that you are tackling this really important issue, and I just read a New York Times article. It was in January. The sleepy Copyright Office in the middle of a high-stakes clash over AI. It was quite an informative article, mainly, talking to you. But I know that you and your team are working on reports on the relationship between artificial intelligence and copyright, and this is a topic, as I mentioned, of great interest and concern to me and this committee. AI is a powerful tool that should be used to enhance and support creativity, but we have to make sure that we don't sacrifice our artists, authors, actors, musicians, singers, songwriters, journalists, and other creative professionals. Our copyright system exists to incentivize and compensate these creative professionals. And the framers of our Constitution cared so much about supporting the creativity of all of these individuals that they actually put protecting copyright in our Constitution in the intellectual property clause. So what you're doing is really important. So getting back to how are other countries dealing with the AI issue and the creative community in their countries?
I would say that other countries are like us, examining the issue, trying to figure out the right way forward. There are a few countries that have enacted very specific exceptions in their copyright laws for text and data mining, which they either have said they will apply, or there is speculation that will be applied to generative AI training. But these exceptions have not yet been tested in court, and we don't know how the courts will apply them and the extent to which the results will be different from our fair use doctrine. I will say there's a lot of conversations going on internationally. We're talking to our counterparts. Everyone is sharing information. The World Intellectual Property Organization is holding regular, what they call online conversations about the new technology issues, and they're all focused on generative AI right now.
Considering that other countries don't have to deal with, I don't think, the issue of First Amendment freedom of speech considerations, is that another a factor for us to consider when we're talking about regulating and making certain requirements of disclosure and compensation?
It could be. Other countries are concerned about free expression and do have some protections for it, but they don't have the equivalent of our First Amendment.
So where are you in working on this report? When will the report be due? And I understand that you have gotten thousands and thousands of comments from
10,000.
people.
10,000, and I will say It's not the maximum we've ever received. We got more for our study on Section 512 of the DMCA a few years ago, but a lot of those were duplicates. These were 10,000 substantive individual comments, so it's taken a lot of analysis and a lot of review. So as you know, the first part of the report was issued the end of July. We have been trying to set and follow our own ambitious deadlines because we know there's a lot of interest. We know these are important issues. So our current goal is to get the other two sections out by the end of the year. We are working hard toward that goal, but to me, what is most important is to make sure that we are accurate and thoughtful and produce a high-quality report that will be useful to you and to the courts.
Well, my best, because whatever you all come up with, I think we're going to see litigation in this space. So we shall proceed. Thank you very much, Mr. Chairman.
Thank you very much, Senator Hirono. Let me just begin a second round by briefly asking about the Copyright Claims Board. I was actively involved in the legislation that created it. I'd just be interested briefly in hearing about your efforts to introduce the public to it, to publicize it, to get more participation. And in reviewing some of the basic data about it, it seems there's only been about 24 final determinations out of 1,000 claims filed. Could you help me understand why?
It's interesting, and you, of course, know the statute even better than I do. I think the process was set up to make sure that inappropriate claims didn't get through and that this didn't become an environment where there were frivolous claims, claims that weren't really copyright claims, and so that's what we are seeing. So a large number of the claims that come in, I believe close to half, and I'd have to check the numbers, don't make it through compliance review. And often it's because they're really patent claims or they're claims brought against someone in another country, which the CCB doesn't have jurisdiction over. And then there are people who, there are various reasons why the claims don't meet the requirements of the statute. And often people have trouble completing service of process because the service rules can be complicated.
Well, I look forward to staying in touch about what, if anything, we can do to help improve it and help it achieve its goals. I really want to focus on piracy, if I can.
That's fine.
Copyrighted content is being pirated now that streaming services are very widespread. Piracy has taken a whole nother leap. By some estimates, it's costing the creative community here in the United States and industries that are built on creative works $30 billion a year and thousands of American jobs. Some of our peer countries, developed democracies, are now using no-fault injunctions as a way to prevent this. I'd be interested in your sense of the contours of who's doing a good job at it, what are the components, as we're considering possible legislation, what we should be looking at. The other thing I'm interested in hearing about is safeguards. What sorts of safeguards other countries have put in to ensure that protected material isn't improperly removed? Look forward to your comments.
We now have seen, as of about a year ago, there were at least 33 countries that had implemented the no-fault injunction possibility. And what we're seeing is that what they have done is more and more put safeguards in various forms. One type of safeguard is to make sure that you're targeting those websites that reach a pretty high threshold of being dangerous. So websites that are dedicated to infringement. We're not talking about a website that might just happen to have some infringing content on it. So that threshold is very important. And then different countries have different standards in place that generally talk about proportionality and balance, taking into account the interest in access to information, for example. So the injunctive relief should be narrowly focused and targeted and directed in an appropriate way so that it doesn't overreach and it doesn't cover too much content. I would be happy to provide, the details of some of these laws after the hearing, but what we are seeing is that where you've got these laws that are provided with appropriate safeguards and balance, that more and more studies are showing that this is effective in reducing piracy at least when you apply it to more than one website, when there's a number of sites in the given jurisdiction.
My sense is some of the injunctions issued in other countries are dynamic, meaning they're going after essentially a business model that says, here's 50 Disney movies that you can access on this site for free. And when there's an injunction placed against that specific URL, they just shift to another, shift to another, shift to another. And they've tried to structure injunctions that can track that shifting. Is that accurate?
Yes, that's my understanding as well.
I'm very interested in our moving forward in this area because I think this is putting us at a competitive disadvantage that we aren't utilizing this. And I look forward to working with you on getting input on what would work and what would work best in this field. Let me defer to my colleague and friend, Senator Tillis.
Ms. Perlmutter, we're hearing some concerns about protecting live events such as sporting events and privacy. Would an expedited removal scheme under DMCA be a possible solution?
An expedited removal
Scheme under DMCA.
More expedited than it currently has?
Right.
For live events specifically. That's an interesting concept, and I would be very interested in hearing more about it.
I was curious. I was raised by my staff. I had some feedback after you all did the new rule, I think, for group registration for updates to news websites. Got some concerns that maybe I think businesses or publications like Barron's, MarketWatch, Page Six, and others have been denied by the office. Can you tell me whether or not we should have a more expansive definition of what a news site is? So are your thoughts on those denials, whether or not they're appropriate or we have to come up with a more expansive definition?
Yeah, well, I would start by saying I'm very proud of the work we did to get that rule out, the new group registration option. We completed it in record time for any new group registration. It was just over 6 months from the first notice to actually having it be implemented and enforced and usable. It's been in operation for just 3 months. We've had, I think, close to 100 applications at this point. It's all very new, so we are looking at how the existing definitions apply to what types of works. In order to get the rule in place very quickly, we used an existing definition so that we didn't have to go back and reinvent the wheel. And so the question will be now, is it working? And we're committed to continuing to have conversations with the stakeholders about it.
Okay, I'm going to submit, I do have another question I want to ask you, but I'm going to submit a question that I feel like is a little bit in the weeds that has to do with something as simple as photographers. They'll take 2,000 photos in an average wedding shoot, for example. But there are limits right now. I want to just submit the question. I think they were using as an example. They take an average of about 2,000. I think there's a 750 image limitation now. It requires a lot of triaging and work. What do you say to them?
We are planning to increase the limit, and in our new ECS system.
What sort of time frame?
We are going to be, the limited pilot that we'll be releasing by the end of the year, so that's in about 6 weeks, will have within it this e-deposit upload system that people will be able to try, and once that's in force, in effect, and implemented, it will allow 2,000 photographs to be uploaded simultaneously, and we will be able to accommodate that number in the new registration system in a group registration. So the pilot will be by the end of this year, and then we will be working on integrating the pilot with the rest of the system next year and probably the year after, and as soon as we can, we will be making sure that the larger number will be able to be accommodated.
Good. For the purpose, or for my, I'm going to submit some questions for the record, but I always try to give witnesses this opportunity. What's the one question that you wish we asked so that you could give an answer to it? What is it in this oversight hearing that we need to know about that we haven't discussed already?
Public performance right and sound recordings. The Copyright Office has supported adding a public performance right for sound recordings to U.S. law for decades now. The administration over multiple administrations has supported it. There have been bills introduced in Congress, and the United States is one of the very few countries in the world that doesn't have that right. And because most countries recognize foreigners getting the royalties on a reciprocity basis, we are leaving millions and millions of dollars on the table abroad. So that is an area that we would love to see action, where we would love to see action.
That's a real good point. I'm glad you brought it up. What about resources? How are you doing in terms of resources? You've done some modernization with the ECS and other things. Where do you need help in just making sure the plumbing is modernized and as efficient as it can be?
Well, we've
I'm not doing it for your sake. I'm doing it for the sake of the users. You just benefit from it.
Well, we're doing everything for the sake of the users as well.
Exactly.
We really appreciated the funding we got from Congress, 5-year funding for modernization.
Yep.
In 2019. We have been able to make a lot of progress, but we are now looking to expedite and accelerate our work on the registration component of ECS, and in order to do that, we will be asking for additional funds in the 26 budget.
Good. One thing to be helpful as an old project manager is I'd like to take a look at that. We're 5 years down the road. You've had funding. I think you've been a good steward of the money, but I'd like to have an after action on these projects, where they were in terms of time, budget, estimated, complete. That'd be helpful. If you could submit to the record, I would appreciate it.
Absolutely.
Thank you, Mr. Chair.
Thank you, Senator Tillis. Register Perlmutter, thank you for your participation in this hearing and for working with us to ensure that the services you provide are more accessible, more modernized, and we're grateful for your policy input. This, according to my book, is our 9th consensus hearing of this Congress, and I appreciate your partnership. Senator Tillis, we will continue to probe some of the challenging, emerging, and thorny issues at the intersection of AI and copyright and how to combat digital piracy, and we welcome your partnership in those efforts. Members can submit questions for the record for the witness until 5 p.m. 1 week from today on November 20th, and with that, this hearing is adjourned.